Good morning, everyone. My name is Deborah Ogbebor. I'm a graduate of the University of Benin. I'm also a graduate of the Nigerian Law School. Currently a graduate intern at HARLEM Solicitors. Shortly, I'll be discussing the concept of trademarks and trademarks protection in Nigeria. Okay, by way of introduction, I would like to define what a trademark is. A trademark is any sign or design or pattern or anything that distinguishes the goods and services of a particular enterprise from another enterprise. Now, some may ask, what are trademarks? What can be used as trademarks? Trademarks can be anything really, any name, any word, any letter, alphabets, numbers. It could be shapes, it could be smell, it could be taste, if it could be anything. It just has to be something that distinguishes a particular product of an enterprise from another enterprise. Now, we have five categories of trademarks in Nigeria. We have the coined or fanciful trademarks, we have the suggestive trademarks, we have the arbitrary trademarks, we also have descriptive trademarks, as well as the general trademarks. Now, what are coined or fanciful trademarks? Coined or fanciful trademarks are trademarks that have no real meaning. They are from the imagination of the owner or the owner of the particular product. Like, for example, you say, I have, my name is Deborah Ogbebor, then you have I am then OG. That forms some kind of word, and I may use that word as my own trademark for my own particular company. Now, because of its distinctive nature, the owner of such a trademark we have to do more advertising and marketing of that particular product. But the good thing is that it is easy to protect, it is easy to register because of that distinctive nature. Now, the next type of trademark we also have the arbitrary trademarks. These are trademarks that have meanings in real life, but they don't really have any relation to the goods or services that the particular owner or enterprise owner is selling or is putting out there. Now, for example, we have the Apple. Everybody knows the Apple phone or Apple products. They have laptops and everything, but their trademark there, you see on on all their products, there's a sign of an apple. Now, that apple is their trademark. It doesn't really relate to the goods and services that they are rendering, but it is their trademark. Now, the good thing about an arbitrary trademark is that it is easily registrable. It is easily registrable. You can easily register, get it registered, and get it protected because of that distinctiveness. Now, another type category of trademark we also have the suggestive trademarks. Now, suggestive trademarks are trademarks that suggest the nature, quality, or attributes of a particular product, but they don't directly describe the product. Now, for example, we have let's say Sony, for example, being used as a trademark to market lamps, for example. Or we have let's say fast. You say something is fast is being used to describe a um a logistic company or a transport company. Now, the thing about suggestive trademark is that it's easily similar to descriptive trademark, so it has less protection under the law. The next type of category we have descriptive trademarks. Now, this type of trademarks describe the attributes, qualities of these products. And the thing about descriptive trademarks is that they are not eligible for protection under the law, because it may deprive other enterprises from using that particular trademark. For example, we have sweets used to describe or market chocolates. For example, it's too descriptive of the particular product, and it may, if it is registered under the law, it may deprive other enterprises from the use of that particular name. Now, lastly, we have the general trademarks. Now, these are trademarks that they describe the goods. It is the goods itself. It has no distinctive form or nature or anything. Now, this type of trademarks are not protected at all. For example, we have bag, the word bag being used to market a bag, the product a bag, or the word chair being used to describe or market a chair. It will be an unfair treatment to competitors and other enterprises. Now, talking about protection of trademarks, how do we protect, or how can one protect his own trademark? Now, the first way you can protect your trademark is by registering that trademark. Yeah, registering that trademark. You can and how, or what does this registration afford you? Now, if you register your trademark in the trademark registry, one, it will prevent competitors from affixing your trademark on their goods or packaging. Two, it will prevent competitors from exporting or importing goods under that particular trademark. Three, it will prevent competitors from stocking or selling goods under the name of that particular trademark. Now, these are the things that registering your trademark will afford you. And how do you register your trademark? It's simple. You file an application at the trademarks registry, either directly or through an attorney, and you get your trademark registered. um another way you can protect your trademark is by use. You protect your trademark by use. I know normally in the normal parlance, it's first to file that gets priority. But if you're able to prove that you by use over time, you've gained acceptability, wide acceptability by using that particular name, then you can get priority over somebody that filed. I don't know if you understand what I'm saying. If you have established your name and acceptability by the public with that trademark, even though you didn't register it first in time, the law will still favor that particular um, competitor or enterprise owner. Okay, and then there's also the concept of business name and trademark. A lot of people mistake business name and trademark. They interchange it, but it is different. A business name is the name that you use in registering your business or your company at the point of registration at the Corporate Affairs Commission. It is completely different from a trademark. Now, a trademark is any sign or anything that's used to distinguish your product from the product of another enterprise. A particular company can have different trademarks, like Nigerian bottling company, for example. They have Coca-Cola, they have Fanta, they have so many trademarks. Now, it doesn't limit, or it doesn't serve as the name of the company. So there's that. In conclusion, trademarks in Nigeria usually normally last the duration for trademark protection in Nigeria is 7 years, but it is, however, subject to renewal. Thank you very much. I remain Deborah Ogbebor.